So I'd like to start, first of all, by welcoming you all to the Access to Remedy and Corporate Accountability session for the first UN Pacific Forum on Business and Human Rights. How exciting. I hear it went really well yesterday. My name is Shelley Marshall. I'm from RMIT University and I'll be chairing this session. I would really like to acknowledge and thank the organisers. Thank you, Yun, you've been so helpful to me in setting everything up. And we have Catherine. Catherine, I'm so sorry, but I can't see your second name or names here, but thank you so much for helping us set up. And just so that everybody online knows that I'm absolutely incompetent when it comes to running the online aspects of things. So we're very, very lucky that we have Catherine here helping to run things. Very importantly, I want to acknowledge the Wurundjeri people of the Kulin Nations as the traditional owners of the unceded land, which the university that I work on stands. It always was and always will be Aboriginal land. And I invite each of you, as you speak or ask a question, to acknowledge the Indigenous people from the land that you speak on today as well, or to connect with us as First Nations people in the way that you traditionally do that or feel moved to today. This session is particularly important for First Nations people who, because of colonial violence and colonial land acquisition, particular vulnerabilities, and also the very important relationships with land and sea as carers and custodians, have been vulnerable and require very often are at the first line of trying to get access to remedy. So before I introduce the session and speakers, I just wanted to provide a couple of running notes. I really want to encourage a lively conversation, so please feel free to put your comments and questions in the chat as we go. We will have short introductory thoughts from each of our esteemed speakers before opening up to a question and answer. And during that question and answer session, you can either put your hand up, the little Zoom hand, or you can put a question in the chat, and I'll try to keep my eye on both. And I'm sure that Catherine will as well. So the topic for today is access to remedy, which remains a key challenge for communities and worker groups whose human rights are breached by business. And this challenge is even greater when the business is domiciled out of the country where the breach occurred. Communities and workers lack information about avenues for accessing remedy, and they often lack capacity to make claims, especially legal claims, which require incredibly technical knowledge and resources. Power asymmetries between Pacific Islander communities and worker groups and transnational business are especially large, making claims even harder and making this session even more important. So in this session today, we're going to be assessing and exploring different avenues for resolving grievances and providing remedy to communities and workers whose human rights are breached by business. We're going to be trying to pull apart the factors that communities and worker groups should consider before bringing a claim. And I know many of you in the audience are experts, people who advise communities. So I'd really love to hear from you when we can come to that speaking point. I'd like to discuss the assistance that communities and workers can access when making these claims, and also talk about the challenges for business and how business can address grievances in good faith. So this session will explore a range of fora and discuss cases that have been brought by Pacific Island claimants against transnational business. Now, because Australian business is a big player in the Pacific, we have speakers concerning Australian avenues for remedy, as well as from the Fiji Human Rights and Anti-Discrimination Commission. But we're going to start by hearing a really personal story about the challenges of making a claim. And this is really important because this is our starting point, I think, for this conversation, rather than diving into the technical detail of what the avenues are and and how claims can be made. Really, our premise needs to be understanding what the problem is. So the order of our speakers that we're so fortunate to have today will be Jo Moses, who is an anthropologist and studying law at the moment, and has been a Paga Hill claimant or representative. I'll be giving him more of an introduction before he starts. Then we'll hear from Padma Raman, who's the Chief Executive of the Australian Human Rights Commission. We'll move on to Ashwin Raj, who is the Director of the Fiji Human Rights and Anti-Discrimination Commission, and then hear from John Southalan, who is the independent inspector for the Australian Human Rights Commission and a barrister and mediator as well. So we'll be getting a lot of fantastic information, covering a lot of ground, and we'll need to be very careful with our timekeeping. I've been asked to leave to try to wrap things up 5 minutes before our session ends. So I apologise to all our speakers if I discipline you to try to keep us on time, or if I wrap things up when we're having a really lively conversation. But I do encourage you to think about how else we can keep this conversation going after we end. So that's our fantastic session program. And it now gives me great pleasure to introduce to you Jo Moses. After graduating from the University of Papua New Guinea as an anthropologist in 2012, he was elected by the Paga Hill community to represent them as their leader and chairman to fight for their rights to equal participation in development. After taking the matter to court, his life was under threat after presenting the case through a documentary film titled The Opposition. And if you haven't seen that film, I really recommend it to you. That film was shown at the 2016 Transparency International Conference in Panama and at the Sydney and Melbourne Film Festivals, where he presented the case during question and answer sessions. And I think this is a really fantastic case study in how to get the story of what is happening to communities out to the world. He's now studying law to enhance his understanding in the field of human rights at the London Metropolitan University. So Jo, can I ask you to unmute yourself and to give us a 7 to 10 minute synopsis of how your community have been trying to gain remedy. I don't know if you're unable to unmute yourself, and I can't see you at the moment in the speakers. Catherine, can you see Jo? He was online earlier.
He's dropped out apparently, so perhaps.
All right, we'll keep moving, and hopefully he'll be able to join us. Catherine, are you able to send him a private message so he knows when he joins that we'll be coming back to him?
Absolutely.
Thank you so much. So it is my great honour then to introduce Padma Raman, who's the Chief Executive of the Human Rights Commission. She has a long established career committed to protecting and advancing human rights. Prior to her current role, she established the Victorian Law Reform Commission, which she ran for 9 years. And she sits on a number of boards, including the Governance Advisory Board for the Australian National Contact Point under the OECD guidelines for multinational enterprises. We're very lucky to have her knowledge and expertise in this field. Thank you so much, Padma.
Hello there, can you hear me?
Yes, very well.
All good? Wonderful.
Yep.
So before I begin, I'd like to acknowledge the traditional owners, the Gadigal people of the Eora Nation, as I sit in beautiful downtown Sydney. It is their land, and pay my deep respects to their elders, past, present, and emerging. So I've been asked really just to speak about the Commission and our role around business and human rights. So I'm going to give you a very brief introduction, and hopefully we can delve into any questions you have further down the track. So the Australian Human Rights Commission is what we call a A-status national human rights institution. It was established in 1986. As such, we're an independent statutory organisation established by law, charged with protecting and promoting human rights in Australia. So the Commission carries out its mandate through education, public awareness campaigns, through our investigation and conciliation service, which is how we deal with complaints, by contributing to policy and legislative development. Last year, for example, we received over 15,000 inquiries seeking information around discrimination and human rights. That usually translates to just over 2,000 actual complaints. We know Australia has a significant number of people from the Pacific community living here. For example, many have come to work in our seasonal workers program in the agricultural sector to fill labour shortages in Australia. We also know that migrant workers in Australia are particularly vulnerable to labour exploitation, including modern slavery. The Commission has some capacity to assist people from the Pacific who are living in Australia to resolve grievances that relate to Australian business through our complaint handling function, but it is quite a limited function because, and this will surprise lots of people, but Australia doesn't actually have a Bill of Rights or constitutional protection of human rights, or even a Human Rights Act or Charter. So the way we've implemented our international obligations is largely through anti-discrimination law. So for someone to complain to us, they would have to link their complaint to either race, nationality, or gender, I think would be the most relevant ones. So our laws cover discrimination on the basis of gender, disability, race, age, religion, political opinion, nationality, and also trade union activity. And it has to be in the context of the delivery of goods and services, or be in an Australian workplace. So if you're a migrant worker in Australia and you're being discriminated against in the workplace on the basis of your race or nationality, you could bring a complaint to us. Our complaint handling process is completely confidential. I can give you an example of a complaint that has been through our process. It's obviously de-identified. We had a complainant in her 50s of Indian Fijian background. She'd been employed as an executive assistant and claimed that her manager sexually harassed her and made comments relating to her race. She resigned because of her manager's behaviour. That complaint was conciliated and resolved with an agreement that the organisation pay her $15,000, provide her a statement of service, write a letter to her expressing regret, and also introduce training and workplace policies. This is a pretty standard sort of complaint model where we resolve disputes through a conciliated process with usually an apology or some form of financial compensation. But most importantly, what we also look for are those systemic outcomes like changes to processes and practices. Our service is free of charge and there's no requirement for legal representation. We offer interpreters and are able to accommodate various types of disability as well. So when a complaint can't be resolved through our conciliation process, then the complainant has the option to go to court. And I guess it's important in Australia to know that there are other avenues for migrant workers or workers who are finding themselves in exploitative positions. So that we have an organisation called the Fair Work Ombudsman that deals with those sorts of issues. We also have, and they deal with things like sham contracting, underpay of wages. They also can look at discrimination. But they're much more the body that you would go to in terms of worker exploitation. We know that the UN Working Group on Business and Human Rights has been consulting on the issue of NHRIs and remedy for business-related human rights abuses. As you've probably all talked about, the Danish Institute for Human Rights has put out a great report earlier this year that makes a range of recommendations about national human rights institutions and the powers we need to access remedy for business-related human rights abuses. Some of those recommendations and powers that we don't have include the power to handle a broad range of business-related human rights complaints, not just discrimination, the power to investigate business human rights related matters, including through our own motion investigation. The Philippines NHRI has these powers, for example, the ability to collaborate with other NHRIs on cross-border complaints. This is something that we try and do informally, but don't have any actual power to do it. So I think there are some of the things that we would really push for. The UPR process is one that's coming up for Australia, and if anyone's interested, we've got some fact sheets around the sorts of things that we would like around business and human rights to increase our powers to be able to actually provide remedy. There are also other indirect ways that we work to support the work around business and human rights. We have a small policy section in our commission that does a lot of advocacy work and awareness raising work around business and human rights. We were involved in the development of the Modern Slavery Act in Australia, and our unit also helps businesses respond to the Modern Slavery Act using a sort of human rights due diligence approach. We've done a range of publications. We've worked with KPMG. We've just produced some guidance around the construction sector and also the financial services sector around modern slavery, because that's the Modern Slavery Act came into effect in Australia last year, and a lot of the business and human rights activity has really sort of, well, modern slavery has been the hook for a lot of business and human rights work. In the past, we've also done some interesting capacity building work. For example, in 2018, we did a capacity building program for Pacific National Human Rights institutions, state agency offices and civil society aimed at reducing the risk of exploitation in labour mobility programs, both in Australia and in New Zealand. The other indirect way that we can work on these issues is we've got a national inquiry power, which allows us to look at systemic human rights abuses and brings to a fore a range of powers, including compulsion powers that, that the Commission can use. Recently, we did a national inquiry on sexual harassment in the workplace. It came out earlier this year. The inquiry involved a really major survey. The Commission's done surveys every 4 years on the prevalence of sexual harassment in the workplace. We conducted that survey again and had extensive public consultations, thousands of submissions, many confidential, interestingly, to that process. The final report was published and made a range of recommendations for government employers and community to better prevent and respond to sexual harassment in the workplace. There has been a real uptake, largely because of a range of incidents in Australia around high profile incidents around sexual harassment. So there's been a real uptake of those recommendations and an increase awareness around sexual harassment in the workplace. I guess the other role that we have is to support the Australian OECD contact point. It's one of the few avenues, I guess, for complaint for people affected by Australian business conduct anywhere overseas, including the Pacific. One of the big issues we've faced is that lack of extraterritoriality or that jurisdiction overseas. But I know John's going to speak about the national contact point, so I might leave it at that. I guess the other avenues in terms of support in Australia, we have got a really good network of community legal centres across the country, and a pretty strong trade union network as well. So in terms of providing advice on avenues for redress or remedy, they would be other points of call that you could make contact with. I might just stop there. I didn't even look at my clock to see if I've gone over 7 minutes.
No, you've done well. You've done very well. You're under 10 minutes. Thank you. And thank you for covering so much in that time. I just want to quickly ask you one question that was in the chat, and then we'll move on so that we can have a fuller conversation. But it's actually a question from John Southalan, who asks, thanks for the stats on inquiries, and could you give us an indication of what percent of those concern business as opposed to individuals? And I would add to that, what does that tell you about people's knowledge that they can actually make complaints against business, and their willingness to do so?
Right. The exact percentage, but I will just need to check that with someone who's actually on premises today.
Come back to that then.
Yeah.
When we're in our Q&A later on. Thank you so much for that really wonderful synopsis. So we'll now hear from Ashwin Raj, who is the Director of the Fiji Human Rights and Anti-Discrimination Commission, who is in person in Fiji, formerly an academic. He's now the Director. He was also the chairperson of the Media and Industry Development Authority from 2013 and 19, and has served on the boards of NGOs working on human rights, rule of law and democracy. Thank you so much for joining us, and I hope you can hear us clearly and it's all working well in the room there. Ashwin, I invite you to tell us about the role of your work in trying to give access to remedy.
Good afternoon, Shelley, Padma, and fellow panelists. Thank you very much for having me on this panel. Just like the Australian Human Rights Commission, the Fijian Human Rights Commission, has a number of powers under the Constitution, and this includes the power to investigate, receive complaints, afford remedies. That includes either mediation or institute proceedings in a court of law, monitor compliance of the state in terms of its obligations under international law, making recommendations on existing or proposed laws, ensuring compliance, and promotion, protection, and preservation of a culture of human rights, both in public and private. So the Commission has a broad range of powers, and including the ability to institute proceedings. And the Commission has, over the years, investigated a number of complaints, on human rights issues, including allegations of cruel, degrading, and inhuman treatment at the hands of law enforcement agencies, labor-related matters, and issues of non-discrimination. Unlike the Australian Human Rights Commission, the Fiji Human Rights Commission operates in a bit of a liminal space at the moment, because it has yet to gain its accredited status after losing it in 2007. all sorts of political reasons that we can talk about later. But that hasn't, derailed the Commission from being able to, exercise its constitutional powers, which, as I said, under the Constitution and under the Human Rights Commission Act, are pretty broad-ranging. One of the things that the Commission actually is doing in terms of business and human rights, and I want to say, just as a prefatory remark, that more than ever in the context of the existential threat around climate change and COVID-19, we've had to sort of think about the relationship between economy and ecology, and the need to respect fundamental rights and freedoms, and particularly in the context when people are losing their jobs. There is the invocation of force majeure, act of God, to let go of workers and all of that. How much of it constitutes a breach of contract and all of that. The Commission has also worked in the area of human trafficking. In 2016, we managed to get the passports of a number of Filipino workers in the construction sector, back to them when it was confiscated some 2 years ago, from their employer. And just last week, we were dealing with some other foreign nationals and the confiscation of their passports, and also the suspension of other sort of work-related benefits. So the Commission also works particularly in the area of vulnerability as it affects women and children in the workforce, around exploitation, around other benefits such as leave, maternal leave, and all of that. So there are a number of areas in which the Commission very, very actively works in holding businesses to account. But the work is particularly accentuated. The importance of the work is particularly accentuated in the current context, where there is, we are operating in an environment of economic malaise, where the suspension of rights, is quite, fragrant, particularly in the private sector. And we categoristically, take our cue also not only in terms of the mandate of the Commission, but also given the fact that the guiding principles are non-binding. What we are doing is actually looking at the existing legal framework and how we can use that categoristically to be able to afford remedy, to be able to restitute rights where there's been an interdiction, and hold businesses to account, but also constructively engage with them. Because when we look at it, there are sufficient provisions in our law that enables us to do that. So if you look at our Bill of Rights, the Bill of Rights of the Fijian Constitution can be applied both vertically and horizontally. So that means, not just holding the state to account, but also private actors. So that's a good thing. The other thing, of course, is there are a number of ancillary legislations in place that allow the Commission to hold the private sector to account. This includes the Employment Relations Act, the Human Rights and Anti-Discrimination Act, the National Gender Policy, the number of international treaties that Fiji has actually ratified, and more recently, this includes the ILO Convention on Violence and Harassment in the Workplace, the Convention on the Rights of Migrant Workers and their families, and that's been very, very useful for us, particularly so in this current context. I mean, the preoccupation with the states and citizens, where strangers fall through that gap, is particularly accentuated. And so we're looking at not just Fijians, but we also look at foreign nationals. The Commission's also considered co-strangulating with fellow national human rights institutions, given the fact that we're looking at seasonal workers, from the Pacific, working in countries like Australia, New Zealand, picking fruits and all of that. And there's been numerous complaints about the conditions of work there. Of course, in the context of curfews and other forms of restriction, it disproportionately affects the ability to enjoy other fundamental rights and freedoms, such as freedom of assembly, association, and expression and so on and so forth. And therefore, the National Human Rights Commission has an important role in ensuring that, we strike the right balance between the imperatives around, public health and national security and so on and so forth, and the right to freedom of speech, expression, opinion, publication, so on and so forth. And so, it's a diabolically opposed, but seemingly diabolically opposed, but mutually constitutive relationship. And so the National Human Rights Commission, once again, has an important role there. One of the things we're actually doing is we're constructively engaging with the private sector as well through the National Human Resource Institute. We've been talking to them about a number of things around the principles of non-discrimination, and we think that this needs to be, that kind of conversation is important because you homeopathically inject that, into the landscape, so that there's enough of that proliferation of that kind of consciousness that these are, actually set in our laws. It's not, something that you do because it's, feel good. There's actually a legal obligation. And so what we are trying to do is derive a number of principles from the guiding principles, and then actually distilling it to say, well, how does it align with the national legislative framework? And where do we actually go to ensure that there's some teeth around it? And I think you need to straddle and radically oscillate between universalism and particularism. So wherever, in the local context, there is some resistance to a particular sort of kind of legislation, we always draw on international principles as well. And the good thing is that the Constitution actually allows for the application of international law under the Bill of Rights. So that's where we are with the role that the National Human Rights Commission is actually playing in ensuring that business and human rights actually have a harmonious relationship, and they can nourish each other. It's become particularly more vexed because in the current economic climate, there's a lot of conversation about also boosting the economy and ensuring that business is in the room, having those, as an ally. How do you do that while also holding them to account? And it's actually done in consonance with the principles of human rights and human dignity. Thanks.
Thank you for covering so much in a short time. We have just one quick question that I think would be useful for you to respond to in the chat, which is, does the Fiji National Contact Point sit within the Human Rights Commission? It's from Olivia Dean, who says that she can see on the OECD website that Fiji is a member of the OECD, but is that right?
So Shelley, not within the Human Rights Commission.
Right.
Yeah.
And John has provided a link to the list of current national contact points.
Great, thank you.
Are you able to tell us anything? Is there a national contact point in Fiji? I appreciate that doesn't sit under your authority.
Yeah, one of the things that I did want to say is that, we need to start thinking through a national plan of action. And the reason why I made the remarks that I did was we really need to, do a mapping in terms of what exists, identify the stakeholders, bring all of those people together and begin to seamlessly map this thing so that we're able to critically appraise what exists on the ground. Of course, the National Human Rights Commission receives complaints and is able to dispense with its mandate to resuscitate rights where there's been an interdiction. However, this obviously, the great thing about the guidelines is that it breaks the silos, and it can only work if you bring all of the various sectors together. So state, civil society, the National Human Rights Institution, academia, communities, and communities often, slip through the cracks and crevices. So I think the guidelines actually, can create the conditions of possibility for a number of entities that would otherwise sometimes be, in a small place like ours, where there's so much propinquity, but at the same time, you know, when you know there are binaries, you know, in terms of political differences and all of that, it becomes really, really difficult. And I think the guidelines afford that kind of, you know, common language and a platform from which, you know, everyone can actually, you know, talk across those differences and ensure that the goal is collective. So that's what needs to happen. And the fact that I can't even tell you who the contact, you know, point is quite telling of the kind of dissonance that at the moment, you know, is present. But that I really think that the guiding principles is what would create the conditions of possibility for all of these, you know, entities to come together. Because sometimes when the private sector is, you know, is taken to task, obviously, you know, they get very defensive and they're like, well, you have no powers, and we have to kind of remind them, hang on a second. Actually, under the Constitution, is both vertical and horizontal application. Yes, we can hold you to account. And so for the longest time, I mean, somehow the other, there's been this whole sort of, you know, in the normative prescription, it's always the state which, you know, has the primary responsibility of holding rights and all of that, and almost as if the private sector has got no part to play. And, you know, this kind of, you know, impresses on everyone that it, you know, the state is but a partial and incipient fragment in the entire kaleidoscope, and that, you know, this is the role that the private sector has to play. And particularly so in the current context, you know, around climate change, around COVID-19, and other transboundary challenges around human trafficking and all of that. Yeah.
Well, that's a really fantastic introduction to our next speaker. And I should add that Joe's internet dropped out, but he's trying to get back in to this session on his telephone. So when he does, then we'll introduce him again. But John, thank you so much for joining us. John Southalan is a lawyer, mediator and academic based in Perth, Australia. He also has the part-time role of independent examiner with the Australian National Contact Point for the OECD guidelines on multinational enterprises, which you just heard Ashwin talking about. He was previously, he's previously worked with NGOs in Australia, Thailand, and also Dundee University, the Australian Human Rights Commission, and the law firm Cause Chamber Westgarth. John, I would just like to start by noting that you have provided fantastic notes that are available for the audience in the session notes. I'm not quite sure how to access them. And Joe also provided notes, which I think is really useful. So thank you so much. Over to you, John.
Thanks very much, Shelley. Yeah, so the notes are available on the SHED website, and all the cases and standards and materials I'll discuss today, I've put them in there as links so that people can get to the actual documents. And if there are questions that I see, I'll also try to put it up in the chat when I've got time. But first, let me thank you, Shelley, for the introduction and to be able to speak with the other panelists here, Padma and Ashwin, and I look forward to hearing from Joe. And I'd also like to acknowledge the traditional owners. I'm on Whadjuk Budja Noongar country in Perth, as Shelley said, and pay my respects to their elders past, present and emerging. It's been useful to hear this, because I think an introductory point that's good to understand about the OECD guidelines for multinational enterprises, which I'm now just going shortened to the OECD guidelines, is that there's a bit more flexibility to that. And so we heard from Ashwin and we heard from Padma about what their commissions can do and the legal structures and the legal options they have, and the remedy potential under the OECD guidelines is a bit more flexible. It's essentially a mediation or an engagement, which is voluntary, but at the end of that, there will be a public statement. And so that sometimes causes, I guess, some confusion or some difficulties from many players. You know, lawyers, how does this work? What can you do? What can't you do? And businesses, why should I engage with that? But hopefully, I'll give a quick talk about how these work and give two cases from the Australian National Contact Point. And then I'll stop there, and if in question and answer we want to talk a bit about how to prepare to make a complaint, I'm happy to talk about that. So the OECD guidelines, these things have been about for 40 years or so. There's not a lot of awareness at times that they're there, and particularly in the last 25 years, any country that has joined these OECD guidelines, and that includes all the OECD members and also a number of others. And in the link in the chat, I put everywhere that is a country that's joined them. They have to encourage business to follow them, and you might be thinking, well, that's a bit vague. But they also have to establish a thing called a national contact point, and the key aspect of that for remedy is that a national contact point then can receive complaints if anyone thinks a business is not following these guidelines, make a complaint to that national contact point, who then looks at the issue, determines whether it's within the guidelines, if so, to try to bring the parties together. The OECD guidelines are very broad. They cover many topics, environment, consumer protection, labour relations, many issues. I guess the key one for this session is they talk about human rights, and particularly they essentially pick up the UN guiding principles on business and human rights. So the idea of business must have policy, business must have conduct due diligence, and where through that they're aware of impacts, business must look at remedy. So if you have a business that you're dealing with, that you're thinking, well, they're not following the UN guiding principles, one option may then be a complaint to a national contact point to say the UN guiding principles aren't being followed here. That of itself is inconsistent with the OECD guidelines, and it's something that we want the contact point to help facilitate some engagement on that. So the UN guiding principles is a useful, I guess, further material to use, and you'll see in the paper that I provided, the OECD have issued many sector-specific guides. So they'll say in the extractives area, this is really what's expected of extractive businesses under the guidelines, or in the agricultural supply, or in garment making, or in finance. So there's a lot of these guides. They're very useful materials to use. Have a look through that again. If you're finding that you're dealing with a business and they're not following these things, obviously the first point, and I think this was a good point made by Ashwin, engage there. And if that's not getting anywhere, then through a complaint to a national contact point might assist. Shelley, I might just take 1 minute perhaps to talk about two cases that the AusNCP, the Australian National Contact Point.
Time. Go ahead.
Okay. So and these, I guess, indicate sort of different outcomes of that flexible process. The first one was a complaint against ANZ Bank in relation to some lending it made in Cambodia. And I should also specify everything I'm saying here is publicly available through the statements. And I have to make that clear because I was involved in the mediation, and in mediation, as you understand, some aspects are confidential within the mediation, but I'm just speaking here what's publicly available. So the ANZ made this loan many years back, and there were impacts, social environmental impacts. It was in relation to a sugar refinery project in Cambodia. And ANZ openly say now, or said in their AGM, that they didn't do adequate due diligence before making that loan available. The relationship between the customer and ANZ ended and finished, essentially paid out the loan, I understand. But there were still ongoing impacts that the communities were suffering. And so a complaint was made to the Australian National Contact Point. Interestingly, after that relationship had ended, but the complaint said ANZ as a business has a connection with what's happened here. ANZ as a business made profits through that, and the communities, they were represented by NGOs in Cambodia and in the United States. So the complaint was made through them with the communities to the contact point in Australia. And over some years there was engagement, mediation, conciliation, some statements out of that, but the final result in January or very early February this year was ANZ agreed to pay over the profits, all the profits it made from that project for the use of the communities in Cambodia. And you'll see the link there. You can get to the statement and see what was agreed in that case. So that was one example where complaint had been made. The company was prepared to engage in the mediation, and there was an agreed outcome. The second, I guess, course might be the company doesn't want to engage. And the example of that is a complaint against a small media and public relations company in Australia called Mercer. And I think I have a link. Yes, I have a link on the bottom of the second page. So this was in relation to some very sad events in Nauru. There's a immigration detention centre there that the Australian government had established, and a person had been assaulted in there, and some of this person's details and medical records were made publicly available through this company who were acting for the Nauru government, advising the Nauru government. And so a complaint was made again to the Australian National Contact Point saying, look, here's problems with human rights impacts about privacy and other areas. In this case, the company didn't want to engage. They said, we're not wanting to engage with that process, and so there wasn't a mediation. But the process, as I explained, involves the contact point making a public statement at the end, and so the contact point made that statement and identified deficiencies and areas that needed to be worked on, and you can click on the link to get that statement there. So it is, and at the end of the day, it's that engagement process and a statement. So I guess I want to be very clear about that. The National Contact Point process is not somewhere where you can say, we want something enforced and we need an outcome of this right which has been breached. So don't go to it expecting that. But I think the ANZ case in particular does show the strengths of, even where something may not be legally required, so this certainly wasn't required by the law of Cambodia or Australia, there's potential there for the national contact points to really assist with an access to remedy. I think I might leave it there. Shelley, I can make some comments on mediation if we want to get there.
Yeah, wonderful. Thank you so much. So I put a question in the chat that I would really love to turn to now, which is, what are the gaps? What are the gaps in the human rights ecosystem for remedy? And I really appreciate that for our speakers who are representing institutions, there might be limits to what you can say about your own, or the bodies that you work for. So generalized comments would be welcome, but I would really like people from the audience to jump in here, because I can see of our participants, there are people who have worked on claims, there are claimants, And so I'm really interested to hear what their frustrations are, and what they think needs to happen to make access to remedy easier. So jump in. Anyone? Ashwin, you have already talked about the need for a kind of an assessment of the terrain for Fiji through a national action plan. But, and also that at the moment your commission isn't registered. What do you think needs to happen from the perspective of Fiji to give better access to communities and workers who are affected, particularly by transnational business?
Obviously, despite the fact that the Commission is undergoing that accreditation process and is working very closely with the Asia Pacific Forum of National Human Rights Institutions, I think it's imperative that we need to form, some kind of triangulation between the national human rights institutions, between the various states, across the region, because you're dealing with a number of issues that are transboundary in nature. Of course, there are jurisdictional implications. It's also about how does one adjudicate on issues of this nature. But, I think we need to recalibrate how we do our business, precisely because, the nature of these challenges are transboundary in nature. Also, you're dealing with, not just the traffic of bodies. We need to start thinking about the traffic of rights. You see what I mean? When rights are locked within the nation state framework, and we're unable to sort of evacuate it from the vicissitudes of that kind of categorical anxiety and tie it to bodies that cross borders, we've got a problem. And that's where the restitution of rights becomes a really challenging thing. So I think, we need to think about how fellow national human rights institutions and states can sort of, work collectively. The other is that we cannot naturally assume that the state and the National Human Rights Commission are on the same page about a number of these things, because the imperatives are very different. So, for some people, the valorization of surplus value would be the most important thing, right? And in the current context, the point is that, right now people would want, businesses to be there because that's the economic engine and that's the powerhouse. Right now, a number of people might be thinking, look, human rights considerations can actually, wait for a little once we have the economy going. That's the base on which we're going to build the superstructure. All of those things can come back. Our argument actually is, in this whole discussion about building better, as part of that whole recovery from COVID-19, human rights and human dignity has to be part and parcel of this conversation. So to what extent states actually seriously bring back national human rights institutions into that conversation with business community is going to be very, very important. You have things like the Chamber of Commerce, you have, Employers Federation, you have, other regulatory statutory bodies that regulate the conduct of, businesses and all of that. That is very different from what national human rights institutions do. And right. So necessarily bringing that back into the algorithm is going to be very important. Because it's not a natural sort of transition. You know what I mean? Yeah. Yes. Yeah.
Between institutions within one nation.
So that's the aperture dissonance that I think we need to,
Right.
Sorry. One of the big things in our region is we don't have a regional mechanism. We're the only region that doesn't have a regional mechanism, right? So it's wonderful to think about how we might work together as national human rights institutions, but there is no mechanism that, sometimes I've even thought, wouldn't it be fantastic if the Asia Pacific Forum for National Human Rights Institutions could somehow turn itself into some sort of regional mechanism? We have an ASEAN Intergovernmental Commission on Human Rights. Again, that's a sort of, it's as close as you get maybe to having some sort of regional mechanism, but it doesn't really have any powers around remedy, as we're talking about. I mean, the gaps are just endless. The gaps domestically and the gaps regionally and globally are endless. But I think it is an evolving space. And, you know, I was talking about modern slavery yesterday to a group of risk officers and businesses. And just seeing these, you know, it's 10 years since the guiding principles were adopted, and we have seen a slow evolution in terms of at least business accepting that human rights considerations are things that they need to turn their minds to, and the risk to people is something that they need to turn their minds to. It's been much, I mean, a lot of businesses have done in terms of ESG, they've done the eco part of it. They're now slowly moving into the social part of it. So I think there's real opportunity to be putting more pressure on our governments. One of our UPR recommendations is that we should have a national action plan on business and human rights. Australia doesn't have one. And that developing one would give us some of that baseline information that we need. But, you know, we don't have enforcement powers as the Commission. We don't have a national charter. We don't. So if we wanted to talk about gaps, we'd be here for a long time. So I think in some ways we almost need to be thinking about how can we be more creative. One of the things we did with the Philippines Commission around an Australian owned mining company was to write to them together as the two national human rights institutions. At least to say, we're watching you, we're here and we're watching you. I'm not sure that we could have done anything, but we didn't point that out to them. That we were aware of what was going on, and we were aware of the complaints, and that we were watching. So I think Ashwin and I have had many constructive conversations, but we need to keep those conversations going, Ashwin, about how is it that we try and become creative in the absence of more formal mechanisms in the region. I guess the only mechanism we have, at least for extraterritorial violations, is through the national contact point.
Great. And I think I can see that Joe has just joined us via telephone. I would really like to hand over to you, Joe, to hear about, and I think this, you know, is a great point, in fact, to come to you about the struggle that the Paga Hill claimants have had, and what the barriers are that you've experienced along the way. I'm so sorry that it's been so hard to stay in this meeting because of internet. Oop. All right, over to you.
Oh, okay. First of all, I would like to thank Shelley, Dr. Luke, for giving me the opportunity to participate in this program. I am really honored, and I want to thank everyone for attending, and I'm hoping that whatever that I will present will help us in some ways, one or another. Okay, I'm pretty sure that you should have a copy of my presentation notes, and so I will briefly go through the information that I got on hand, and we'll try and discuss a few things after the Q&A and see where we go from there. Anyway, thank you all. Okay, based on our legal fight against gross human rights violation, I can state the following. This has been a merry-go-round for quite a while. It's been a couple of years. I've been, trying my best to make things happen. Unfortunately, there's so many stumbling blocks and stuff like that. And the crimes committed back home, particularly the Paga Hill Seafront, downtown Port Moresby in Papua New Guinea. We are all aware of the event that took place in Port Moresby. That was the APEC summit. And so they decided to remove the community which were living at near where the conference was taking place. And so that's what actually happened. What they did was they demolished the homes, destroyed properties, and forcefully evict all community members who were living around the precinct. And so since 2012, I've been involved with the legal battle against some agencies or part of the state, as well as a few private entities who were partly, not partly, but in one way or another, they were engaged in the, I would say, conventional crime, which I prefer to categorize that in that degree. What they did was they came in, they destroyed the homes. They did not help the community members in terms of their rights to express themselves. And so there was so much that was going on. And so I decided to take up the case and tried my best to restore some kind of cohesion and some kind of dignity back to the community, particularly the members. And so as it happened, the homes are destroyed and everything. Everyone are scattered all over Port Moresby. Some have gone home to their respective provinces, and some are still living around Port Moresby. There was a resettlement program that was conducted by one of the private companies that was engaged by National Capital District to do a kind of some form of restitution, but unfortunately it was way, way below UN standard. And so that was my fight that I did engage a few indigenous lawyers. Unfortunately, there was so much suppression from the government side. There are few prominent politicians who were part of the whole scenario who also participated in the sense that they used their finance and their power to maneuver things, and they did try their best to suppress us as much as possible. And so since what eventuate, I began to seek legal redress on the whole issue. And I also found out that there are business entities who have special interest in that particular piece of land. And there are also individuals, including the National Capital District. And so it kind of, the whole scenario, it's so complicated that we cannot really point our fingers at one particular person. And so this is a case of so many people involved and are not following the right protocol. They kind of maneuver a situation in a way that they don't care about human lives. And so they engage police personnels and private contractors to participate in the demolition exercise that took place in 2012, 2013, and 2014. I had the privilege of working along with Media Stockade Australia, and we came up with a documentary called The Opposition. We filmed what actually transpired, and then we decided to screen the film as part of the awareness and also as part of our evidence against what transpired. Unfortunately, there was a huge pressure from the government that the Supreme Court judge decided to suppress our activity, not to screen the film, and also the company who was involved in the destruction decided to take up the matter with the Supreme Court in Australia, the National Court in Australia. And so it had been going on for quite a while. Eventually, Media Stockade and the team won the case. And so we were given the green light to screen the movie, the documentary. And so the case is so complicated that we went to court, and we were the plaintiffs, telling the court that this particular company were the ones involved in the destruction. And then as time goes on, we realized that it was not this particular company alone. There were other entities that were kind of, they come together, but they have their own interests. They have their own legal battles between themselves. And National Capital District was the one that engaged a private contractor that came in 2014 that did the final destruction. They used the police to come in and demolish the whole community, burn everything down to ashes, and chase everybody out. Prior to that, in 2012, there was a company called Paga Hill Development Company. It's partly owned by politicians, private individuals, and mostly some prominent figures who are part of the government agencies, who are using the government departments to maneuver what they really kind of, want to do. And so that's the whole scenario. The government system was so manipulated that it does not serve the people, I would say. National Capital District was against us, the police were against us. The decision from the district court was not in our favor, though we provided all the evidence. They still did not rely on our evidence. And then we went as far as the national court, in which they granted the land back to the community. Unfortunately, National Capital District decided otherwise. They moved in and destroyed everything using a contractor, in which they decided to engage the police to come in and do the final demolition. And so this all amounts to a gross abuse of human rights, and they did suppress our rights as much as possible, that they decided to chase everybody out, and now some are still living on the streets. Mm-hmm. Keaton Brothers was the one that was engaged by National Capital District to clear a place, and some of the community members were resettled there, absolutely without nothing eventually. Mm-hmm. And they just clear the land and just leave the people there, and they fend for themselves. Joe. And so it was really disheartening.
Yeah, it sounds like it. No wonder. What would remedy look like in this situation for the community members? What do they want?
All we want right now is a better restitution and compensation, because at the moment, the current restitution that was conducted by Keaton Brothers and NCD is way, way below UN restitution standards.
Uh-huh. So there has been some restitution, but not adequate restitution.
Absolutely, but it's not adequate.
Uh-huh. Uh-huh.
There's about 200 to 300 families. They're still living on the street, bunking with families and stuff like that. We did a research with Jubilee Australia, in collaboration with Jubilee Australia. We did that, and our report will be published as soon as everything is completed. I will leave that with Dr. Luke to talk about that. And I'm also looking at securing a pro bono lawyer who can take up the legal challenge, because at the moment, it all comes down to finance. Most of the people are scattered, and most of the people who are living in the communities are kind of low wage earners,
Uh-huh.
and they
So when
cannot
you
afford.
say it comes down
They
to finance, it's expensive.
yes,
It's
it is
expensive to
expensive.
do this. Uh-huh.
Exactly, and
So
so
that
that's one of
relates,
the factors.
yeah, absolutely. Yeah. That relates to questions that were put in the chat about not just, you know, what the available avenues are, but also how to make them accessible in terms of providing assistance and outreach to communities. Joe, what you said, you need lawyers to do this work pro bono. What else would make it possible for the community members to continue to pursue their claim? What kind of support is needed?
At the moment, they are all scattered everywhere, and we need some kind of, I would say, we were planning to look for a place where everybody can come together. We are trying to look for a piece of land, so that everybody who are misplaced and are living on the streets can come together, live in that particular piece of land, and see how we can maneuver things from there. Because at the moment, it's so difficult to get in touch with many of the community members.
Right.
On the other hand, majority of them are now moving into Garahu. I think it's now called 8th Street. And so we have a good number who are living in Garahu. And so every weekend, you know, once in a while, we have meetings that, you know, are conducted by the community elders to discuss what is going on, what is the latest progress, and what are the chances of us securing a pro bono lawyer and all that. And so we kind of, the whole thing kind of comes to a standstill at the moment because of the pandemic, and yeah, people couldn't move around freely, and so we're trying to operate on a low key at the moment. So we're kind of trying our best to make things happen.
Right. Thank you so much for sharing that with us. We have around 7 minutes until we've been asked to wind up this session. I'm wondering, is there anyone from the audience who would like to make a final comment? We have some fantastic questions, and Joe Gonawai has made a really useful suggestion in the chat as well. But I would like to see if there's anybody who would like to say anything extra from the audience before I turn back to our panel.
Thank you. I have Natasha Khan from USP.
Thank you.
Thank you, Shirley, and all the presenters. There's two questions I had. One to John Southalan. Is there any Pacific Island countries where they've got national focal points for OECD guidelines? Because I'm not very aware of, and I was wondering whether other Pacific Islanders sitting in this room would be interested to know that. Second question is to last speaker, Joe, I believe his name.
Yes.
He mentioned that the issue was the evidence itself, the process of the court, it was problematic. Is there a need for human rights defenders to be trained on collecting evidence, evidence that stands up to scrutiny in the court? Is that important enough?
Yes, absolutely. We have that in place. In actual fact, one of my youth leaders, he was in Australia working along with Luke and the team, with the Media Stockade and others. He did attend a few international, human rights courses, and he also did some help in collecting evidence. Even myself, I was involved with that. I did some, prior courses to do the information gathering. We have enough evidence, and with the help of Professor Laslet from Ulster University. And to top it up, we have the documentary film directed by Holly Fiper with the collaboration with Media Stockade Australia and British Documentary here, Society here in UK. And so we've got a great team working together to get the evidence together, and we'll come up with a very powerful empirical evidence, I would say, to go against the government of the day. Because at the moment, though, in a way, the government is not directly involved, but people who are within the government system, they're the ones having interest in that particular piece of land, and they are the ones kind of controlling the system. And so it's a matter of time, I would say. If they're still there, the case will still continue, or the community members might, decided to, do their own thing and stuff like that, because it's been quite a while now, since 2012.
Thank you, Joe. I'm going to hand over to John for his the question that was addressed to him as well.
Sure, thanks. Natasha, I think it was. Apologies if I missed that name. I'm not aware of any national contact points in any Pacific, sort of key Pacific states. There's certainly New Zealand, Japan, Korea, Australia. But the answer to this is to think of supply chains and to think of product value chains, because sometimes it might be that this direct company, there's no national contact point you can go to, but where are their financiers? Where's the investment coming from? Where is the product being used? And I put up in the chat, and I just say to people, if you look for the company POSCO, P-O-S-C-O, if you put in a Google search POSCO and national contact point, you'll come across a case which was involved concerns about impacts in India. India doesn't have a national contact point. It was a South Korean iron and steel company, and two of their investments were very small amounts from Norway and from the Netherlands. And so there were complaints made to those contact points related to the impacts in India. And so it's being used in that way, even though there wasn't a contact point in India.
That's really helpful. Are there any final questions or comments from the audience? That's the online audience and the in-person audience. No, then are there any last statements or comments from our panel? I'd like to invite you to, if there's anything further that you wanted to say earlier.
That's something that I want to say.
Thank you.
Due to the fact that the case is taking so long, we're kind of trying to figure out what is the best option. And so our option now is looking at helping ourselves. And as time goes on, and if the need arises, we might reactivate the case. I am still waiting for Jubilee Australia, particularly Dr. Luke, to make the report available so that we can base our kind of ECU based on the research findings that will give us some kind of fair ground to maneuver and move forward. And I'm pretty sure that things will look brighter, because the current government is kind of more into grassroots level, and it's the bottom-up development program that the government is pursuing. And so I'm really kind of hopeful that things will eventually change. Thank you.
Thank you so much. And with just a few closing comments that are in the conversation, making note of the really important point that was raised for national human rights institutions to find ways to collaborate. I think that was a great point to come out. Obviously, I know that you're in non-stop communication, but that point about having a regional body, I think, is so important. thank you, John, for bringing attention to the fact that national contact points, there are inventive ways to find links with national contact points, even where the incident may have occurred in a country where there is no national contact point, or it may involve the primary company might not be linked to a country with a national contact point. And then this really important issue, which I think Joe's presentation has brought home, which is just the amount of work and the amount of assistance which is required in training human rights defenders, in providing assistance in making claims, and also just in letting people in the Pacific community know about what the options are. And this is a really important step along that way. So I really appreciate the attendance of all of you. Padma, you look like you're trying to say one last thing.
There's a question from the audience.
Hi, Bula. I think my question is directed at to Ashwin Raj, Mr. Ashwin Raj. You talked about the Bill of Rights, and so I think yesterday we were talking about the EIAs and whatnot, and so I was just wondering whether your organization also is working on some of that, when we're talking about that and the accessibility of indigenous landowners, resource owners, and all. And also I think my other question would be how do we make complaints to you and to your organization? Is it easy and is it expensive? And also I think my other question would be, when I remember my other question, I'll let you know. But yeah, for now, that's just, that's just what I wanted to know, how accessible to raise concerns with you, and because we're doing business and human rights, if your organization has taken to court maybe businesses that has infringed on human rights.
Yes. Okay. Shelley, with your approval, if I can, very quickly. So the question around the EIAs, that's for people outside Fiji, it's about environmental impact assessment. I absolutely agree with you. One of the things we are pushing for with the environmental impact assessment is that, there's got to be transparency with the environmental impact assessment. I mean, that it intersects with the right to information. It intersects with the right to be able to robustly critique these environmental impact assessment, statements and all of that. There's greater transparency and public scrutiny and participation in the process because of the fact that this, invariably affects everybody. There's this whole issue around the common good. So that's the first thing. And this is why I keep talking about how the Bill of Rights actually creates the conditions of possibility for that kind of introspection, precisely because you can do both vertical and horizontal application of the Bill of Rights. So the second question about how to lodge a complaint with the Commission is fairly straightforward. We're at 9 Goodenough Street, Level 2, Nambati House. You can email your complaint to us. And the manager complaints in the room is actually going to give you our contact details and all that. You'll find us on the Facebook page as well. One of the things that I wanted to make abundantly clear to everybody is that we investigate on the basis of confidentiality. We ensure that we don't expose our complainants because of the worries about reprisal and recrimination. The other thing is that, it'll cost you not a single penny. If we take a matter to court, it's on us. And that's why also, given, the constraints around resources and all of that, we're very, very careful with the kinds of cases that we need to absolutely take to court. What are the cases where we can, use the ADR model, and it's much more cost effective and all of that. But to anybody who's, who wishes to lodge a complaint, it's not going to cost you a penny, and your name need not go out there. And you can also lodge a complaint not only on your behalf, but it can be on behalf of a third person. The law allows for that, and on the basis of anonymity. Thank you.
Can I ask a question?
Oh, I am really sorry, but we actually need to wrap up. I apologize, but I was given instructions to try to end on time, or 5 minutes early if possible.
Okay.
So we're actually over time now. But I'm really thrilled that this conversation is hotting up, and I encourage us to find ways to continue it. I'll certainly be pursuing that. Joe Moses, Padma Raman, Ashwin Raj, and John Southalan, thank you so much for your really fantastic comments and insights today. And thank you all for joining us with this session. Let's find ways to continue the conversation. Thank you.
Thank you.